to Mr. Spicer when we are ready to. At this point, after the arraignment, we would ask Mr. Levy to surrender his passport at this time.
Okay. Thank you, Mr. Williams. So, Mr. Spicer, what I'm going to do today is I'm going to adjourn Mr. Levi's case until May 23rd in hopes that the DA's office hasn't already provided you with a pretrial offer and have you report on that pretrial offer on that day at 9:30 in the morning on the 23rd. Does that work, Mr. Spicer, that day?
Judge, let's keep that in. I'm supposed to start a trial on May 19th. However, I don't believe that's going to be a long trial. So I think the 23rd should work okay.
Okay. Mr. Williams, would you like to be heard in regards to bail?
Yes, Your Honor. As Your Honor has noted, Mr. Levy is mentioned in 6 counts of this 11-count indictment, with his top charge being murder in the second degree. Obviously, Your Honor does know that the exposure on murder in the second degree is up to 25 to life. He does not have a criminal history based on the district attorney's knowledge. However, due to the facts and circumstances of this case, the defendant's special relationship in regards to the decedent in this matter, the people would be asking for $500,000 cash, $1 million bond, $2 million partially secured.
Mr. Spicer?
Thank you. Yes, thank you, Judge. As I would note that Mr. Levy is 38 years old. As Mr. Williams noted, he has no prior criminal history. He's a 17-year veteran of the Department of Corrections as a corrections officer. He's a lifelong resident of the Mohawk Valley, has 2 children, ages 8 and 11. His parents also live in the area. He has retained counsel. He's been engaged with me, and we've had thoughtful and fruitful discussions up until now. He has turned himself in as directed in New York State Police Barracks earlier today. And I think what's also notable, Your Honor, is although his employment with the Department of Corrections has been interrupted, he promptly gained other employment with a local contractor, Judge. So I think all of those, his family ties, his children, his lack of any criminal history, and the fact that he remained in the jurisdiction following this alleged incident, all demonstrate that he is not a flight risk whatsoever, Your Honor. I would further note, Judge, at this point, I'm not able to comment on the evidence or lack thereof against Mr. Levy, so I can't really make any arguments with respect to the prosecution's case. Judge, but I do submit respectfully that Mr. Levy is not by no means a flight risk. I would ask that the court set bail in the amount of $50,000 cash, $100,000 bond.
Having listened to arguments of counsel and reviewing the factors listed in CPL 51010 subdivision 1, and only being able to consider the defendant's risk of flight, the court will set the bail in the amount of $100,000 cash, $250,000 bond, and $1 million unsecured bond with a 10% deposit. Mr. Levi, I'm going to hand you a copy that I want you to go over with Mr. Spicer regarding Parker warnings. We'll go over with you if you do post bail and you do get released. Mr. Levi, you have a right to be present in court at any proceeding, including in particular a hearing and a trial. Do you understand that?
Yes, sir.
You can, however, by your conduct, waive, give up, forfeit, or lose that right to be present. If you disrupt the proceedings, the law permits the court to exclude you from the courtroom, commit you to jail, and continue the proceedings, including a hearing or trial in your absence. Do you understand that?
I understand, sir.
If you deliberately fail to appear here for a trial, that will constitute a waiver, a forfeiture of your right to be present. A warrant will be issued for your arrest. The trial will continue in your absence. If there is a verdict of guilty and you again deliberately fail to appear for the sentence, you will be sentenced in your absence, and upon your arrest, the sentence will be executed. You will also be subject to separate prosecution and separate punishment for bail jumping, no matter what happens at that trial. And any bail money will be forfeited. Any property will be forfeited as well if that's used as collateral. You understand all of that?
I believe so, sir.
Can you please go over that, Mr. Spicer, in writing and sign that today? I'm going to get you a copy of that before you leave today.
Thank you, sir.
Your Honor, there's one final matter I do want to discuss. We did, as I stated previously, provide Mr. Spicer a copy of our 71030 notice, and there are specific notices in regards to identification as well as statements. However, we understand that we do have a 15 days post-arraignment, and we may supplement that 71030 notice with additional information once it
Understood.
becomes available.
And Judge, I would acknowledge receipt of the 71030 notice, and of course, I understand what Mr. Williams is saying. So, okay.
Thank you.
Thank you, Judge.
All set, we'll see you back on the 23rd.
Blair.
Good afternoon, Your Honor.
Good afternoon. This is the matter of the people of the state of New York against Caleb Blair under indictment I 2025-090. Are you Caleb Blair? Why don't you just walk right up to that microphone?
I am, Your Honor.
And what is your date of birth?
June 6, 1994.
Is that on?
June 6, 1994.
And how old are you right now?
30 years old.
And Counselor, can you just state your name for the record?
William Sullivan.
Mr. Blair, the United County Grand Jury has returned an indictment against you. That indictment charges you with murder in the second degree, manslaughter in the first degree, gang assault in the first degree, gang assault in the second degree, conspiracy in the fifth degree, and offering a false testimony for filing in the first degree. You have a right to be represented by counsel in this matter, and Mr. Sullivan will be representing Mr. Blair in this matter.
Yes, Your Honor.
You have a right to a trial by jury, and you have a right to testify at that trial if you so choose. Mr. Patrick, if you would like, you can ring the bell.
Thank you, Judge. For the record, Sarah Fitzpatrick, as Special Prosecutor representing the people. Pursuant to indictment number I 2025-090-1 through 10, the people of the state of New York versus Caleb Blair. The grand jury of the county of Oneida by this indictment accuses Caleb Blair of the felony crime of murder in the second degree, pursuant to in violation of section 125.25 subsection 2 of the penal law of the state of New York. This is an 11-count indictment. Does counsel waive further reading?
Yes, counsel.
I note for the record, Judge, that 6 counts do apply to this defendant. Attached to the indictment I provided to defense counsel are this people's standard pretrial notices. Specifically, the people do intend to use identification evidence as well as admission or confession evidence. Similarly, as Mr. Williams stated with the previous defendant, we may be supplementing that 71030 in the future within the next 15 days. However, that does contain a flash drive with many of the statements and identifications that people do intend to use at trial.
Okay, again, Mr. Sullivan, your receipt of that document.
Judge, I acknowledge receipt of the indictment and the attached notices to enter not guilty plea.
The not guilty plea will be entered. Mr. Sullivan, I'm going to adjourn your case, or Mr. Blair, I'm going to adjourn your case until May 23rd at 9:30 in the morning for you to report on any offer made by the district attorney's office. And at that point, if you're not going to accept an offer, I'll give you a motion schedule at that point. Mrs. Patrick, would you like to be heard in regards to bail?
I would, Judge. This defendant has no known criminal history to the people. However, the top charge out of the 6 that he is included in this indictment is the felony crime of murder in the second degree, as Your Honor is well aware. Therefore, exposing this defendant to a serious amount of incarceration period should he be found guilty of such charges. As a result, that does increase the risk of flight, and the people would similarly be requesting, as we did with the co-defendant Levy, bail to be set in the amount of $500,000 cash, $1 million bond, $2 million partially secured bond, but we also would respect your Honor's decision should you set bail in the same amount as the previous co-defendant.
Mr. Sullivan, would you like to be heard?
Yes, Your Honor.
Go ahead.
Judge, Mr. Blair was born in Rome, lived here in this county his entire life. He was homeschooled by his parents through 9th grade. Thereafter, attended Rome Catholic, and he graduated from Rome Catholic in 2013. He then went on to study at SUNY Poly, got an associate's degree there in accounting, then went on to serve his country in the National Guard, but has always kept Oneida County as his home. He was married with children. He is a member of a local church and was very involved in there. And Judge, I know the court addressed bail on the first case call in reference to statute. There's no risk of flight, Judge, none whatsoever. He's been in contact with me since early March. This incident is alleged to have occurred on March 1. 6 weeks have passed, Judge. I would submit to the court that if he were going to flee, that would have happened already. He has not. He's retained counsel. He's been in contact with me. He surrendered himself to the New York State Police at Marcy this morning. He was told to be there at 11 a.m. I understand he arrived early. As we were advised by the people that the police would be waiting for him. He's not a flight risk, Judge. I would ask the court set bail in the amount of $50,000 cash, $100,000 bond, $200,000 partially secured.
The court has considered arguments of counsel, and again, referring to CPL Section 510.10 Subdivision 1, specifically factors including the charges facing the defendant, that being the top count of murder in the second degree, where he faced up to life in prison if convicted, and the factor, did this individual, the allegations involved causing harm to an identified individual. Based on those factors and arguments of counsel, I will set bail in the amount of $100,000 cash, $250,000 bond, and $1 million unsecured bond with a 10% deposit. And Mr. Blair is ready to surrender a passport if you have that. Again, Mr. Sullivan, May 23rd, 9:30 in the morning.
And I do have a passport, Judge.
Mr. Blair, before you go, I want to go over some warnings with you. Mr. Sullivan has a copy of what I'm about to tell you in writing, so if you just follow along. Mr. Blair, you have a right to be present in court in any proceeding, including, in particular, a hearing and trial. Do you understand that? You can, however, by your conduct, waive, give up, forfeit, or lose that right to be present. If you disrupt the proceedings, the law permits the court to exclude you from the courtroom, commit you to jail, and continue the proceeding, including a hearing or trial, in your absence. Do you understand that?
I understand.
If you deliberately fail to appear here for a trial, that will constitute a waiver, a forfeiture of your right to be present. A warrant will be issued for your arrest. The trial will continue in your absence. If there is a verdict of guilty, and you again deliberately fail to appear for sentence, you will be sentenced in your absence, and upon your arrest, the sentence will be executed. You will also be subject to separate prosecution and separate punishment for bail jumping, no matter what happens at this trial, and any bail money and or property that is used as collateral will be forfeited. Do you understand that? And you agree to appear at each and every court appearance that you do make bail?
I do, Your Honor.
Okay, can you just please sign that?
Thank you, Judge.
Thank you, Mr. Sullivan. people of the state of New York against Francis Chandler under indictment I 2025-090. Are you Francis Chandler?
Yes, sir.
And what is your date of birth?
2889.
And how old are you?
36.
Mr. Chandler, the United County Grand Jury has returned an indictment against you. That indictment charges you with the crimes of gang assault in the second degree, manslaughter in the second degree, conspiracy in the fifth count, 2 counts of conspiracy in the fifth degree, offering a false instrument for filing in the first degree, and tampering with physical evidence. You've been brought to court to be arraigned today. Mr. Williams, you may arraign.
Thank you, Your Honor. In Oneida County Court, the people of the state of New York versus Francis Chandler, indictment I 2025-090-1 through 10. The grand jury of Oneida County by this indictment accuses defendant Francis Chandler of the crime of gang assault in the second degree. Counselor, do you waive a further reading?
Waive a further reading, Your Honor. Good afternoon, enter plea of not guilty.
The not guilty plea will be entered. Mr. Chandler, in regards to this indictment, you have a right to be represented by counsel, you have a right to a trial by jury, and you have a right to testify at that jury trial if you so choose. And Mr. Vadnais, you are representing Mr. Chandler on this matter. Okay. Again, what I'm going to do today is adjourn this case until May 23rd at 9:30 in the morning, with the hope that the DA's office will provide you with a pretrial offer, and you return to report on that offer. And then if the offer is going to be rejected, we'll give out a motion date, or motion schedule at that point. Mr. Williams, would you like to be heard in regards to bail?
Yes, Your Honor. And before I be heard in regards to bail, may I address one issue?
Of course.
Your Honor, we did attach to the indictment that has been provided to Mr. Vadnais our standard 71030 notice, which has our standard pretrial notices as well. Specifically attached to it are notices of identification as well as statements. Also attached to it is a physical thumb drive that contains interviews of the defendant. And like, I apologize.
Oh, no, go ahead.
Like the prior defendants, in regards to the 71030, there may be a supplemental 71030 within the 15 days that we're statutorily obligated to turn over.
Understood. And you're going to receive that?
No, I've received that, Your Honor.
Thank you. So, Mr. Williams, at this point, I'll ask you, do you have an argument as in regards to bail?
Yes, Your Honor. The top count that Mr. Chandler is charged with is gang assault in the second degree. As with the other co-defendants, there is no prior criminal history that my office is aware of. In regards to Mr. Chandler, however, he was a supervisor in regards to the allegations contained in the indictment, and allegedly provided no assistance to stop the allegations in regards to Mr. Nansweet. Due to that, the people would be requesting $75,000 cash, $200,000 bond, $500,000 partially secured.
Mr. Vadnais, would you like to be heard?
I would, Your Honor. Mr. Chandler is 36 years old. He has no prior criminal record. He's been married for 13 years. He has 2 children, ages 11 and 6. He is working as a self-employed concrete person right now. He's lived here his entire life. He was employed. He grew up in Oneida County. We've been in constant contact with the district attorney's office and came here on a half-day's notice to appear today with respect to this indictment. My understanding is that $50,000 cash, $100,000 bond would be more than sufficient. Mr. Perau is prepared to raise that bond right now. Beyond that amount, we have some difficulty. So we were asking if that was a possibility with respect to this matter. He does not have an active or valid passport, and we'd ask that the court set it in $100,000 bond, so that could be made today.
The court has considered the arguments of counsel, and again, looking to CPL 510.10 subdivision 1, the 2 most relevant factors being the charges facing the defendant today, those being C violent felonies where he faces up to 15 years in state prison if convicted, along with the fact that this crime involves actual harm to an identified individual. The court will set bail in the amount of $50,000 cash, $100,000 bond, and $500,000 unsecured bond with a 10% deposit. Wednesday mornings, I've given the other defendants, you could follow along, and then ultimately sign that paperwork. Mr. Chandler, you have a right to be present in court in any proceeding, including in particular a hearing and trial. Do you understand that?
Yes, sir.
You can, however, by your conduct, waive, give up, forfeit, or lose that right to be present. If you disrupt the proceedings, the law permits the court to exclude you from the courtroom, commit you to jail, and to continue the proceedings, including a hearing or trial in your absence. Do you understand that?
Yes, sir.
If you deliberately fail to appear here for trial, that will constitute a waiver, a forfeiture of your right to be present. A warrant will be issued for your arrest. The trial will continue in your absence. If there is a verdict of guilty, and you again deliberately fail to appear for sentence, you will be sentenced in your absence, and upon your arrest, the sentence will be executed. You will also be subject to a separate prosecution and separate punishment for the charge of bail jumping, no matter what happens at that trial, and bail money and property would be forfeited if you avail yourself of these proceedings. Do you understand that?
Yes, sir.
And you agree to be here at each and every court proceeding?
Yes, sir.
All right, you can sign that. We'll get you a copy of that before you leave. And Mr. Chairman, the next time we need to be here is May 23rd at 9:30 in the morning.
Judge, we just asked that you ask the defendant to surrender his passport sometime today or in the near future.
I thought Mr. Evans indicated he didn't have a passport.
He does not have a valid passport, Your Honor. We'll be happy to turn that in. I just asked that it not be held up in terms of his release, but we'll turn that in either today or tomorrow morning.
That's fine.
So, I do, Your Honor. All set, Your Honor.
We're all set. Thank you.
Thank you, Judge.
Thomas Act.
Judge, good afternoon.
Good afternoon.
Michael Kazmarek appearing on behalf of Thomas Act.
Director, just come up right to that microphone just so we can hear you. This is a matter of the people of the state of New York against Thomas Act under indictment I 2025-090. Mr. Act, the United County Grand Jury has returned an indictment against you. That indictment charges you with manslaughter in the first degree, gang assault in the first degree, gang assault in the second degree, 2 counts of conspiracy in the 5th degree, offering a false instrument for filing in the first degree, and tampering with physical evidence. In regards to this indictment, you have the right to be represented by an attorney. And Mr. Kazmarek, you're going to represent Mr. Ack on this matter.
I am, Your Honor.
You have a right to a trial by jury. You have a right to testify at that trial if you so choose. Ms. Patrick, if you'd like to arraign the defendant, you may arraign.
Pursuant to indictment number I 2025-090-1 through 10, the people of the state of New York versus Thomas Act The grand jury of the county of Oneida by this indictment accuses Thomas Act of the felony crime of manslaughter in the first degree in violation of section 125.20 subsection 1 of the penal law of the state of New York. Of this 11-count indictment, 7 of the counts apply to this defendant. Does counsel waive further reading?
Judge, we waive further reading, acknowledge receipt of the indictment as well as the people's notices pursuant to section 71030, enter a not guilty plea on behalf of Mr. Eck to each count.
The not guilty plea will be entered on your client's behalf. Mr. Kazmarek and Mr. Eck, I'm going to adjourn your case until May 22nd at 9:30 in the morning for the DA's office to provide you with a pretrial offer and have you report on that offer. If the offer is not acceptable at that time, we'll get a motion scheduled at that time. At this point, Ms. Fitzpatrick, do you have any recommendations as to bail?
Yes, Judge. Given the charges that this defendant is facing and the potential incarceration exposure should he be found guilty of them, thus increasing the risk of flight, the people would be asking for bail in the amount of $100,000 cash, $200,000 bond, $500,000 partially secured bond.
And Mr. Kazmarek, would you like to be heard?
Judge, I would. Judge, Mr. Eck is a lifelong resident of Oneida County. He has family here. His mother and father, as well as one of his siblings, reside in the county. He is a graduate of St. John Fisher University. He had been working for the Department of Corrections for about 8 years. Judge, I'd note that he has no arrests or convictions, as well as no disciplinary actions relative to his employment with the state. Judge, I'd also note that Mr. Eck voluntarily appeared for 2 separate interviews. He appeared here voluntarily this afternoon. He retained my services prior to appearing here. I'd also note, Judge, that after he was suspended by the Department of Corrections, he promptly went out and found gainful employment. He has a child, a son, that he supports financially that relies upon him. Mr. Eck and I have had many discussions about the facts and circumstances surrounding this case, and I can assure the court that he is resolved to answer these charges and clear his name. Judge, I ask that if the court's inclined to set bail, that it be set at $10,000 cash, $20,000 bond, $30,000 partially secured bond.
Having listened to arguments of counsel and looking to the factors set out in CPL 510.10 subdivision 1, for the record, the defendant, the charges he is facing do have a maximum penalty of up to 25 years in state prison, and the other factor that this crime did cause harm to an individual that is identified. So with those arguments in mind, the court will set bail in the amount of $75,000 cash, $200,000 bond, and $750,000 partially secured bond with a 10% deposit. Mr. Eck, I'm going to provide you with a written copy of these Parker warnings. Please follow along. I'd like to go over them with you.
Judge, one note, I did inquire, Mr. Eck does not have a passport.
Okay, thank you. Mr. Eck, you have a right to be present in court at any proceeding, including in particular a hearing and a trial. Do you understand that?
Yes, sir.
You can, however, by your conduct, waive, give up, forfeit, or lose your right to be present. If you disrupt the proceedings, the law permits the court to exclude you from the courtroom, commit you to jail, and continue the proceeding, including a hearing or a trial, in your absence. Do you understand that?
Yes, sir.
If you deliberately fail to appear here for trial, that will constitute a waiver, a forfeiture of your right to be present. A warrant will be issued for your arrest. The trial will continue in your absence. If there is a verdict of guilty and you again deliberately fail to appear for sentence, you will be sentenced in your absence, and upon your arrest, the sentence will be executed. You will also be subject to a separate prosecution and separate punishment for the charge of bail jumping, no matter what happens at the trial. Do you understand that?
Yes, sir.
Do you understand that if you do not appear at a court appearance and there is a warrant issued for your arrest, your bail will be revoked, you will lose any money posted and or property that was used as collateral?
Yes, sir.
And you agree to appear at each and every court appearance?
Yes, sir.
At this point, the only court appearance you have going forward at this point is May 22nd at 9:30 in the morning. call ready today. Mr. Clement, the United County Grand Jury has returned an indictment against you. That indictment charges you with the crimes of manslaughter in the first degree, gang assault in the first degree, gang assault in the second degree, conspiracy in the fifth degree, and offering a false concern for filing in the first degree. In regards to this indictment, you have the right to be represented by counsel. I see Mr. O'Brien standing next to you. Mr. O'Brien, are you representing Mr. Clement on this matter?
I am, Your Honor.
You also have a right to trial by jury and a right to testify at that trial if you so choose. Mr. Williams, you may reign.
Thank you, Your Honor. In regards to Oneida County Court, the people of the state of New York, by indictment I-2025-09-5, the people of the state of New York versus Craig Clement. The grand jury of the county of Oneida, by this indictment, accuses Craig Clement of the crime of manslaughter in the first degree in violation of Penal Law Section 125.20, subsection 1/20.00 of the Penal Law of the State of New York. Counselor, do you waive a further reading?
I do.
Your Honor, we have provided a copy of the indictment as well as the 71030 notice that specifically alleges that identification procedures and statements have been done. Attached to that 71030 as well is a physical flash drive that contains any statements that are initiated by the 71030 notice. We have not filed a COC yet. We would be asking for a passport, if any, to be surrendered in regards to this matter.
Mr. O'Brien, are you in receipt of those items that just described by Mr. Williams?
Your Honor, I am.
And does your client wish to enter a plea?
We'd enter pleas of not guilty, Your Honor.
Plea of not guilty will be entered. Mr. Clement, I'm going to adjourn your case until May 22nd at 9:30 in the morning for you to report on an offer by the people. If you're not going to accept that offer at that point, I will give your attorney a motion schedule as we go forward. Mr. Williams, would you like to be heard in regards to bail?
Yes, Your Honor. Mr. Clement is charged with similar charges as Mr. Egg. We understand that Your Honor did set the bail in the amount of, I believe, $75,000 cash, $200,000 bond, $750,000 partially secured. We would respectfully be asking for the same amount in regards to Mr. Clement.
Mr. O'Brien, would you like to be heard?
Your Honor, I would like to highlight the fact that Mr. Clement is a lifelong resident of New York State. He lives here in Oneida County, and perhaps most importantly, even knowing the potential of the charges, he stayed within the jurisdiction, and he showed up this morning with myself early to be processed by the New York State Police as directed. He's not a flight risk. We look forward to defending his case.
The court has considered arguments of counsel in looking at CPL 510.10, subdivision 1, and the factors set forth. The most compelling factors being the charges facing the defendant at this point of manslaughter in the first degree, that being a Class B felony. The defendant faces up to 25 years in state prison, and the fact that the crimes charged did allege harm to an individual that is identifiable. The court will set bail in the amount of $75,000 cash, $200,000 bond, and $750,000 unsecured bond with a 10% deposit. And Mr. Clement, if you do have a passport, you are to forfeit that as well.
Do we turn that into the court? Or?
Yes.
Okay.
And Mr. Clement, I'm going to provide you with a written copy of Parker warnings that I'm going to go over with you as well. Mr. Clement, you have a right to be present in court in any proceeding, including in particular a hearing and trial. Do you understand that? You can, however, by your conduct, waive, give up, forfeit, or lose that right to be present. If you disrupt the proceedings, the law permits the court to exclude you from the courtroom, commit you to jail, and continue the proceeding, including a hearing or trial in your absence. Do you understand that?
Yes.
If you deliberately fail to appear for trial, that will constitute a waiver, a forfeiture of your right to be present. A warrant will be issued for your arrest. The trial will continue in your absence. If there is a verdict of guilty, and you again deliberately fail to appear for sentence, you will be sentenced in your absence, and upon your arrest, the sentence will be executed. You will also be subject to a separate prosecution and separate punishment for the crime of bail jumping, no matter the outcome of that trial. You understand that? You also understand that if you fail to avail yourself of these proceedings, that any money posted for bail will be forfeited along with any property that was in this collateral. And you agree to appear for each and every court appearance appear May 22nd at 9:30 in the morning.
I already swear that truth in the affidavit. I do, Your Honor.
Daniel Berger.
Are you Daniel Berger?
Yes, sir.
And what is your date of birth?
9779,
And how old are you right now?
45.
Mr. Berger, the grand jury of United County has returned an indictment against you. That indictment charges you with manslaughter in the first degree, gang assault in the first degree, gang assault in the second degree, conspiracy in the fifth degree, and offering a false instrument for filing in the first degree. You have a right to be represented by counsel on this matter. You have a right to a trial by jury, and you have a right to testify at that trial if you so choose. Counsel, can you state your name for the record?
Yes, Your Honor. Michael McDermott, appearing on behalf of Daniel Berger.
Mr. Patrick, Mr. Berger has been brought to the arraignment. You may arraign.
Pursuant to indictment number I 2025-090-1 through 10, the people of the state of New York versus Daniel Berger. The grand jury of the county of Oneida by this indictment accuses Daniel Berger of the felony crime of manslaughter in the first degree in violation of section 125.20 subsection 1 of the penal law of the state of New York. Out of this 11-count indictment, 5 charges apply to this defendant. Does counsel waive further reading?
I waive further reading and enter pleas of not guilty to each count, Your Honor.
And Judge, provided with the indictment to defense counsel are the people's standard pretrial notices. Attached to such is a hard drive that does contain video recordings. The people will intend to use both identification evidence as well as confession evidence in moving forward with prosecution.
I acknowledge receipt of those documents, Your Honor.
And you previously entered a plea of not guilty.
Yes, Your Honor.
All right. Okay, Mr. Berger, what I'm going to do is adjourn your case until May 22nd at 9:30 in the morning for the DA's office to provide your attorney with any pretrial offer that they may be making. If they do in fact make a pretrial offer, when you come back on the 22nd, I'll ask you to report on whether you're going to accept that pretrial offer or turn it down. And at that point, if you do turn it down, we will schedule motions and go from there. Ms. Fitzpatrick, would you like to be heard in regards to bail?
Yes, Judge. Based on previous arguments as well as understanding the court's previous bail being set, this defendant is facing charges similar to his co-defendants that have already been arraigned, in which case the people would respectfully request that bail be set in the amount of $75,000 cash, $200,000 bond, $750,000 partially secured bond, as well as having the defendant's passport be taken at this time by Your Honor.
Mr. McDermott, would you like to be heard?
Thank you, yes, Your Honor. I do have Mr. Berger's passport here to provide to the court. I would note that Mr. Berger is 45 years old. He's married. He's the father of 2 children. He owns his own home in the area. He He has previously been employed by the Department of Corrections for over 20 years. He has no prior criminal convictions. He appeared today voluntarily, surrendering himself upon notice from the District Attorney's Office yesterday. I would suggest the court he poses no flight risk. And with the surrender of the passport, I would ask the court to set bail in the amount of $50,000 cash, $100,000 bond.
The court, having considered arguments of counsel and looking to the factors set out in CPL 510.10 subdivision 1, most importantly, the fact, looking at the charges facing the defendant, he is facing a charge of manslaughter in the first degree, which is a Class B violent felony, where the maximum penalty is 25 years in state prison. And also the other factor is whether or not the crime charged caused harm to an identified individual, and in fact it did. With all of that considered, the court will set bail in the amount of $75,000 cash, $200,000 bond, and $750,000 unsecured bond with a 10% deposit. Mr. Berger, I'm going to give you a copy of Parker warnings, and I'd ask you to follow along with those warnings with your attorney. Mr. Berger, you have a right to be present in court at any proceeding, including in particular a hearing and trial. Do you understand that?
Yes, sir.
You can, however, by your conduct, waive, give up, forfeit, or lose that right to be present. If you disrupt the proceedings, the law permits the court to exclude you from the courtroom and commit you to jail. And continue the proceeding, including a hearing or trial, in your absence. Do you understand that?
Yes, sir.
If you deliberately fail to appear here for a trial, that will constitute a waiver, a forfeiture of your right to be present. A warrant will be issued for your arrest. The trial will continue in your absence. If there is a verdict of guilty and you again deliberately fail to appear for sentence, you will be sentenced in your absence, and upon your arrest, the sentence will be executed. You will also be subject to a separate prosecution and separate punishment for the charge of bail jumping, no matter what the outcome of that trial is. Do you understand that?
Yes, sir.
And you understand if you fail to appear at court appearances, that the bail you posted could be forfeited, and any property used as collateral could also be forfeited. Do you understand that?
Yes, sir.
And you agree to show up at each and every court appearance going forward.
I do.
See you back here on May 22nd at 9:30 in the morning.
And Your Honor, Mr. Bernardo is here, prepared to post.
Correct. And just, it wasn't stated in the defendant did surrender his passport.
Also provided notice of the purpose.
Thank you.
May I put you on?
And Mr. Bernardo, you swear to the truth and affidavit?
I do, Your Honor.
Vitali.
This is the matter of the people of the state of New York against Nicholas Vitali under indictment I 2025-090. Are you Nicholas Vitali?
Yes,
And what is your date of birth?
7/20/92,
And how old are you?
32 years old.
Mr. Vitali, the grand jury of United County has returned an indictment against you. That indictment charges you with misdemeanor count of conspiracy in the 5th degree. In regards to that charge, you have a right to be represented by counsel, you have a right to a jury trial, and you have a right to testify at that trial if you so choose. Mr. Passalacqua, are you going to represent Mr. Vitali on this charge?
Yes, Your Honor. Paslopoulos Nicholas has been retained to represent Mr. Vitali through the conclusion of this matter.
Mr. Vitali, you've been brought to court today to be arraigned. You may arraign Ms. Fitzpatrick.
Thank you, Judge. Pursuant to indictment number I-2025-090-1 through 10, the people of the state of New York versus Nicholas Vitali. The grand jury of the county of Oneida by this indictment accuses Nicholas Vitali of the misdemeanor crime of conspiracy in the 5th degree in violation of section 105.05 subsection 1 of the penal law of the state of New York. 2 counts of this 11-count indictment apply to this defendant. Does counsel wait for the reading?
Yes, we waive reading.
Do you have a plea you would like to enter, Mr. Paslopoulos?
Yes, sir, we enter a plea of not guilty to all charges at this time.
Not guilty plea will be entered. Mr. Vitali, I'm going to adjourn your case until May 15th. And on that date, you're going to return to me and tell me whether or not you're going to accept a offer made by the people. If you are not, then I will give your attorney a motion schedule at that point. Ms. Fitzpatrick, you want to be heard on bail?
Judge, I recognize that this is not a bail qualifying offense. However, given the nature of the circumstances involved in this case, the people would request pretrial release supervision.
Yeah, as you stated, Ms. Fitzpatrick, well, Mr. Paslopoulos would like to hear.
Yes, Your Honor, as Ms. Fitzpatrick acknowledged, this is a non-qualifying offense. As such, we request Mr. Vitali be released on his own recognizance at this time.
The court has considered arguments in counsel, and as Mr. Paslopoulos and Ms. Fitzpatrick has stated, the CPL does not allow me to set bail, as it is a both are non-qualifying offenses, so I must release the defendant on his own recognizance. Mr. Vitali, I am going to do that today. Release you on your own recognizance, you are to surrender. Let me ask you, do you have a passport?
Yes.
I did.
Anthony, Mr. Vitali has surrendered his passport to the court. Mr. Vitali, I'm going to hand you a written copy of the parole warnings. Please take a look at that. I'm going to go over that with you now. Mr. Vitali, you have a right to be present in court in any proceeding, including in particular a hearing and trial. Do you understand that?
Yes, Your Honor.
You can, however, by your conduct, waive, give up, forfeit, or lose the right to be present. If you disrupt the proceedings, the law permits the court to exclude you from the courtroom, remit you to jail, and continue the proceeding, including a hearing or trial in your absence. Do you understand that?
Yes, Your Honor.
If you deliberately fail to appear for trial, that will constitute a waiver and forfeiture of your right to be present. The warrant will be issued for your arrest. The trial court will continue in your absence. If there is a verdict of guilty, and you then deliberately fail to appear for a sentence, you will be sentenced in your absence, and upon your arrest, the sentence will be executed. You will also be subject to a separate prosecution and separate punishment for the charge of bail jumping, no matter the outcome of your trial. Do you understand that?
Yes, Your Honor.
And you agree to be here at each and every court appearance that is set for you?
Yes, Your Honor.
Again, the court is without authority to set bail, so I will release the defendant on his own recognizance. The next time you need to be here, Mr. Vitali, is May 15th at 9:30 in the morning.
Judge, just for the record's sake, the people did hand over the standard pretrial notices, including the use of admission or confession evidence as well as identification evidence to counsel.
I acknowledge receipt of the same.
Thank you, Mr. Vasilov.
Michael Eper.
Are you Michael Eppert?
Yes.
This is the matter of the people of the state of New York against Michael Eppert under indictment I 2025-090. What is your date of birth, Mr. Eper?
November 24th, 1980,
And how old are you?
42.
Mr. Eper, the grand jury of United County has returned an indictment against you. That indictment charges you the charge of offering a false instrument for filing in the first degree. You've been brought to court to be arraigned today. You may arraign.
Thank you, Your Honor. In Oneida County Court, the people of the state of New York by indictment I-2025-090-1 through 10, the people of the state of New York versus Michael Eper, charges Mr. Eper with the crime of offering a false instrument for the filing in the first degree in violation of section 175.35, subsection 1 of the Penal Law of the state of New York. Counselor, do you waive a further reading?
We do, Your Honor. Enter a plea not guilty.
And not guilty plea be entered.
Your Honor, we did provide Counselor with a copy of the indictment. Attached to that indictment are our standard pretrial notices and procedures, specifically with notice of identification procedures as well as statements. Attached to that pretrial notice procedure is a physical flash drive that contains the referenced identification and statements that we mentioned.
I acknowledge receipt of the same, Your Honor.
We would ask for Mr. Eifert's passport to be surrendered at this time if it does exist.
Okay. I assume you're indicating, Mr. Williams, you understand that this is a non-qualifying offense and bail cannot be set.
Well, Your Honor, I do understand that we would not be asked for bail in regards to monetary. We would ask for pretrial release in this matter. I know Your Honor has mentioned that harm was done in some of these cases or some of the counts in the indictment. I do believe that Mr. Eifert's count does also relate to a harm, identifiable harm being done to Mr. Nantui, which the people would submit respectfully would make this bail qualifying, not in monetary form, but in regards to pretrial release.
First, Mr. Eisman, you're going to represent Mr. Eifert on this matter.
Yes, I am, Your Honor.
And do you have anything you'd like to say in regards to that?
Well, it's not a bail qualifying offense, Your Honor. I don't think I need to say much more than that. He's voluntarily appeared here in no prior criminal history. I think he's going to show up as required by the court.
All right. Having listened to the arguments of counsel, the court is going to release the defendant on his own recognizance. Again, this is a non-qualifying offense. The CPL does not allow the court to set bail in this manner. I'm going to require Mr. Eifert, if you do have a passport, that you surrender that passport to the court.
I've inquired, Your Honor, he does not have a passport.
Mr. Eifert, again, the next time you need to be in court is May 15th at 9:30 in the morning. At that time, you are to report on any pretrial offer that is made to you. If there is a pretrial offer and you're going to reject that, at that point, I will schedule a motion date going forward. I'm going to provide you with a written copy of what's known as Parker warnings. I'm going to go over those with you right now. Mr. Eifert, you have a right to be present in court at any proceeding, including in particular a hearing and trial. Do you understand that?
Yes.
You can, however, by your conduct, waive, give up, or forfeit, or lose the right to be present. If you disrupt the proceedings, the law permits the court to exclude you from the courtroom, commit you to jail, and continue the proceeding, including a hearing or a trial in your absence. Do you understand that?
Yes, sir.
If you deliberately fail to appear for trial, that will constitute a waiver, a forfeiture of your right to be present. A warrant will be issued for your arrest. A trial will continue in your absence. If there is a verdict of guilty and you again deliberately fail to appear for sentence, you will be sentenced in your absence, and upon your arrest, the sentence will be executed. You will also be subject to a separate prosecution and separate punishment known as bail jumping, no matter what the outcome of that trial is. Do you understand?
Yes, Your Honor.
And you agree to those conditions and agree to appear at each and every court appearance.
I do.
All right. We'll see you back here May 15th at 9:30 in the morning.
Lawson.
2025-090. Are you Donald Slauson?
Yes, sir.
What is your date of birth?
3/13/72.
And how old are you?
53.
Mr. Slauson, the United County Grand Jury has returned an indictment against you. That indictment charges you with tampering with physical evidence. You've been brought to court today to be arraigned. Mr. Patrick, you may arraign.
Thank you, Judge. Pursuant to indictment number I 2025-090-1 through 10, the people of the state of New York versus Donald Slauson. The grand jury of the county of Oneida by this indictment accuses Donald Slauson the felony crime of tampering with physical evidence in violation of section 215.40 subsection 2 of the penal law of the state of New York. Out of this 11-count indictment, that is the only charge that applies to this defendant. Does counsel waive further reading?
Yes, Your Honor, we waive further reading and enter a plea of not guilty.
Not guilty plea will be entered. Mr. Slauson, in regards to this indictment, you have the right to be represented by counsel, and counselor, could you just state your name for the record?
Yes, Kevin Louis, you're going to have a card for Your Honor.
Mr. Ludevan, you'll be representing Mr. Slauson on this matter.
Yes, Your Honor.
Also, in regards to this indictment, Mr. Slauson, you have a right to a jury trial, and you have a right to testify at that trial if you so choose. I'm going to adjourn your case until May 16th at 9:30 in the morning. At that time, or by that time, the DA's office will provide your attorney with a pretrial offer, and you'll tell me on that date whether you're going to accept that offer or turn it down. If you are going to turn down that offer, I will schedule motions to be filed by your attorney at that point. Mrs. Patrick, would you like to be heard in regards to bail?
Judge, recognizing that this is not a qualifying offense and respecting Your Honor's previous bail, setting of bail on the previous co-defendants, the people will not make any arguments against the release of this defendant on his own recognizance.
So, Lou Ryan, do you have anything you want to add to that?
No, Your Honor.
Okay. All right, Mr. Slauson, I cannot set bail on this. It's what's called a non-qualifying offense. The law does not allow me to set bail. So I have to release you on your own recognizance in regards to this charge. I am going to provide you a written copy of Parker warnings. I'm going to go over those Parker warnings with you. Please follow along with your attorney as we go through those. Mr. Slauson, you have a right to be present in court in any proceeding, including a hearing and or trial. Do you understand that?
Yes.
You can, however, by your conduct, waive or give up or lose the right to be present. If you disrupt the proceedings, the law permits the court to exclude you from the courtroom, commit you to jail, and continue the proceeding, including at any hearing or trial in your absence. You understand that?
Yes.
If you deliberately fail to appear before trial, that will constitute a waiver and forfeiture of your right to be present. A warrant will be issued for your arrest. The trial will continue in your absence. If there is a verdict of guilty and you are again deliberately fail to appear for a sentence, you will be sentenced in your absence, and upon your arrest, the sentence will be executed. You will also be subject to a separate prosecution and separate punishment for bail jumping, no matter what the outcome of your trial is. Do you understand that?
Yes, sir.
And you agree to be present at each and every court appearance that I set for you?
Yes.
At this point, the only court appearance we have right now is May 16th at 9:30 in the morning. Okay? Please just sign that, and it looks like your attorney has your passport. I will take possession of that as well.
And just for the record, Judge, attached to the indictment provided to defense counsel are people's standard pretrial notices similar to all co-defendants.
I'll provide you a copy of that, Mr. Slauson, so you get it. the State of New York against David Perau under indictment I 2025-090. Are you David Perau?
Yes, sir.
What is your date of birth?
12/26/88,
And how old are you?
36.
Mr. Ferrone, the United County Grand Jury has returned an indictment against you. That indictment charges you with the crime of manslaughter in the 2nd degree, 2 counts of conspiracy in the 5th degree, offering a false instrument for filing in the 1st degree, and tampering with physical evidence. In regards to this indictment, you have a right to be represented by counsel, you have a right to a trial by jury, and you have a right to testify at that trial if you so choose. Mr. Ferrone, can you afford your own attorney?
Yes.
Judge,
You are, Mr. Williams.
Yes.
Okay, Mr. Ferrone, I guess maybe the better question is, do you have an attorney at this point? You haven't hired an attorney, that's my question. Have you had a chance to talk to the public defender's office who is present here today?
Yes.
All right. And would you like me to assign the public defender's office to you at this point if you qualify?
Yes.
Mr. DeVigian, have you had a chance to talk to Mr. Ferrone about whether or not he qualifies for the services of the public defender?
I have, Your Honor. He qualifies. We will represent him as long as he chooses.
All right. So, Mr. Ferrone, I'm going to assign Mr. DeVigian to represent you on these charges. You can, at any point, if you can afford an attorney, hire that attorney and have him appear or her appear at whatever court appearance is next, okay?
Yes, sir.
At this point, Mr. DeVigian will be your attorney going forward. Mr. Ferrone, you've been brought to court to be arraigned today. Mr. Williams, you may arraign.
Thank you, Your Honor. In Oneida County Court indictment I-2025-090-1 through 10, the people of the state of New York versus David Perau. The grand jury of the county of Oneida, by this indictment, accuses Mr. Perau of the felony crime of manslaughter in the 2nd degree in violation of Penal Law Section 125.15, subsection 1/20.00 of the Penal Law of the State of New York. Counsel, this is an 11-count indictment. Do you waive a further reading?
Yes, I do.
Your Honor, I have provided counsel with a copy of the indictment as well as our 71030 notice. Specifically, there are notices in regards to identification procedures as well as statements. Attached to that 71030 notice is a physical flash drive that contains the aforementioned statements as well as identification procedures. We have not provided a certificate of compliance at this time as we're still going through discovery. We would ask at this point that the defendant surrender his passport.
Mr. DeVigian, are you now the receipt of the items described by Mr. Williams?
Yes, Your Honor. We'll enter a not guilty plea.
And that guilty plea will be entered. What I'm going to do, Mr. Ferrone, is adjourn your case until May 16th at 9:30 in the morning. At that time, you will return to court and tell me if you wish to accept a pretrial offer of the people or turn it down. If you decide to turn down that offer, I will then give your attorney a motion schedule at that point. Do you understand all of that? Mr. Williams, would you like to be heard in regards to bail?
Yes, Your Honor. Sergeant Ferrone is similarly situated as co-defendant Sergeant Chandler in regards to the indictment. I understand that Your Honor previously set bail with Sergeant Chandler at $50,000 cash, $100,000 bond, $500,000 partially secured. We would ask for that amount as well for Sergeant Perau.
Mr. DeVigian, would you like to be heard?
Yes, Your Honor. From my discussion with him, he has very few assets, if any. He recently resigned from his job with the Department of Corrections, so he's no source of income. He's lived in this area for his entire life. His family's here. He's informed me he has no passport and really no means to post bail. I just request that the court keep it as reasonable as possible under the circumstances.
The court has considered arguments of counsel and looking to the factors laid out in CPL section 510.10 subdivision 1. The two most important factors in this case being the charges the defendants are facing is to risk of flight. This top count, manslaughter in the 2nd degree, the defendant faces 15 years in state prison if convicted, and also the fact that this crimes charge involved harm to an identified individual. So with those factors in consideration, the court will set bail in the amount of $50,000 cash, $100,000 bond, and $500,000 unsecured bond with a 10% deposit. Mr. Ferrone, I'm providing you with a written copy of Parker warnings. I ask you to look at that. I'm going to go over that and follow along. You have a right to be present in court in the proceeding, including in particular the hearing and trial. Do you understand that? You can, however, by your conduct, waive, give up, forfeit, or lose that right to be present. If you disrupt the proceedings, the law permits the court to exclude you from the courtroom and commit you to jail and continue the proceeding, including any hearing or trial in your absence. Do you understand that? If you deliberately fail to appear here for trial, that will constitute a waiver, a forfeiture of your right to be present. A warrant will be issued for your arrest. The trial will continue in your absence. If there is a verdict of guilty and you again deliberately fail to appear for sentence, you will be sentenced in your absence. Upon your arrest, the sentence will be executed. You will also be subject to a separate prosecution and separate punishment for the charge of bail jumping, no matter the outcome of your trial. Do you understand that? Do you understand if you fail to appear at any court appearance and a warrant has to be issued, that you take the risk of your bail money being forfeited and any property that you're using as collateral also being forfeited? You agree to those conditions and to show up at each and every court date that is set for you in the future? All right, Mr. Ferrone, the next time you need to be in court is May 16th at 9:30 in the morning. And Mr. Ferrone, just for the record, I know Mr. Diggins said it, but you do not have a passport. Anything else from the people before you?
Judge, a procedural question. I haven't even thought about offers, but I will make offers. Do you wish to be copied on those if I do it by email? I don't know what.
That would be fine. I just didn't want to adjourn the case out and we're kind of just spinning our wheels. So that would be fine with me. Send me the email.
Right.
That's perfect.
We're all set, Judge. Thank you very, very much.
Thank you.
Judge, I just have one thing for your file.
Sure.
This is just all the people's 7/10/30 notices.